When do I file my I-601 waiver? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, San Diego, and Washington, D.C. So today we're going to talk about 601 waivers. Specifically, we're going to talk about when do you file them. So we're talking about marriage-based green card cases. We're talking about situations where, for whatever reason, the beneficiary is inadmissible. That means they can't get lawful permanent resident status based on the way things currently are. This individual might be overseas and married to a U.S. citizen, or they might be inside the United States married to a U.S. citizen. And this is a fact pattern that we see very often. There's lots of different reasons why someone might be deemed inadmissible. Maybe they entered the United States without inspection. Maybe they overstayed a visa. Maybe they did both those things. Maybe they worked without permission. Maybe they lied or made a misrepresentation at some point. There's lots of different reasons why you might need a 601 waiver. And so in the typical case, a U.S. citizen would file an I-130 petition for their spouse. And if the person's overseas, eventually it would process, and the embassy or consulate overseas would issue an immigrant visa after all the processing is completed. If the beneficiary is inside the United States, they'd file an I-130 along with an I-45 if the petitioner is a U.S. citizen, and the beneficiary, the immigrant, would try to adjust their status here in the United States. But we've now reached a situation in the case where USCIS or the State Department has determined that Benny, the beneficiary, is inadmissible for one of those reasons that I mentioned earlier, or for any of other reasons, of which there are many. So many people want to know, can I file that 601 at the very beginning? Let's say I know my spouse is inadmissible. Can I file a 601 right then? The answer to that question is no. You can't file a 601 until the government deems the beneficiary to be inadmissible and believes that they might be eligible for a waiver. They'll ask you to complete a 601 waiver. You can't file a 601 waiver with the original case. You have to wait to be asked to do it either by the embassy or by USCIS. And a 601 waiver is filed with USCIS. Now, one thing you need to understand is that if your beneficiary spouse, Benny the beneficiary, is going to need a waiver, that's going to add about a year or two to the processing of your case. So they're not going to be adjudicated anytime soon. It's not going to be a quick process, and it's not going to be like the typical process. So the first thing you have to get your mind around is that it's going to take a really long time. Now, some people wait to even think about the 601 waiver until the government asks them to do it. But when we're working on a case, we think about the waiver early on in the process. If we believe that our client is going to need a waiver, we start working on that case at the outset, around the time that we file the I-130. So if we believe that the petitioner would benefit from psychological care or financial support, we're going to start building that case. So if that means that the petitioner is going to start thinking about what would happen if my spouse got deported, or if they weren't allowed to come to the United States, how would that impact my life? What hardships would that impose on my life? They would be going to see a therapist sooner rather than later to start building that record. You don't want to just start your waiver case when they ask for it. You want to be developing evidence over months about why it's hard for your spouse why it's hard for the U.S. citizen to go overseas, or why they can't live overseas, or what health issues they have. You need to build that documentation. If there's psychiatric records or psychological records that can be generated that can show that there would be a real hardship if the beneficiary is not allowed to stay or come to the United States, these are the things you need to think about early. So while you can't file for the waiver at the outset, you can start working on the waiver at the outset. Does that make sense? So you have to be smart, and you have to sort of think of this whole thing as a chess match. What is the end goal? Begin with the end in mind. We want our spouse to be able to come to the United States or to stay in the United States. So what is that going to take? That's going to take a waiver. Well, in order to prove that the waiver should be granted, you have to show that it's going to be an extreme hardship. They understand that everybody who is separated from their spouse experiences hardship. They want exceptional hardship, really high level of hardship. And so if you wait till the last minute, slap together a 2-page letter that says, oh, I can't live without my wife, it really sucks, not going to cut it. But if you have psychological records or financial records or employment records that show that there's a real disparity there if the beneficiary is not allowed to come or stay in the United States, then you're going to have a much better chance of getting that waiver approved. Does this make sense? I hope it does. If you're thinking about filing for a waiver, we like working on these cases. They're very fact intensive. They're hard cases. I think this would be a hard one for you to be able to get approved without an attorney. But if you're thinking about hiring us to work on your marriage-based green card or family-based green card. And if you think someone's going to need a waiver and you want to work with us on that, give us a call, 314-961-8200. Email us info@hackingimmigrationlaw.com. If you are just looking for some free resources, no problem with that. Just join us in our Facebook group. It's called Immigrant Home. You can find us there. There's thousands of immigrants in there talking about the immigration process. You can follow me on TikTok @ImmigrationHacking. Also, you can find us on YouTube, and that's where we're posting this video and where you can subscribe to get alerted when we get new videos up, which is 2 or 3 times a week. Finally, we have our Immigration Answer Show, which is me answering questions from immigrants around the world 2, 3, 4 times a week for free for an hour. We'd love to have you join us there. If you want to get on the text line for that, you can text the word SHOW, SHOW, to 314-470-3300. Thanks a lot, and we'll see you on the next video.